Hello friends, welcome back to Pen and Paper YouTube channel. Here we use simple pen and paper to understand the complex legal topics. So today's topic is if in case you have been misguided by your advocate in a check bounce case, then you should know the reality, especially the legal reality. And in any of the scenarios, if you have been accused in a check bounce case and your advocate who is going to promise you to a way out without payment or accountability, so this video is for you and we will try to break down the law so you can protect yourself with clarity, not confusion. So let's begin the video. So friends, first we need to understand what is a check bounce case or a check dishonor case, which is going to file under section 138 of the Negotiable Instrument Act. So basically, you are the drawer who has paid the check to the payee, and there is a bank which has not paid to the payee on your instruction, maybe because of the stop payment or the there is no amount insufficient of funds or there is a signature mismatch or any of the reason. So then the complainant, the payee is going to file a case in the court under section 138 of the NI Act. So basically the check bounce case is going to arise when a check is going to dishonor due to any of the reasons, and under section 138 of the Negotiable Instrument Act, this is going to be a criminal offense. So most of the advocates will not tell you, they will tell you they are going to uh, protect you, and there is a lacuna in the law, so they are going to find it out. And what happens is they will start giving you some false promises, and you are going to accept them. So basically, most of the cases, what people do is they will give the check and then they will also go to the advocate. They will ask for the advice. Then the advocates they will either give the instructions to the bank, the advice, and they tend to make the check bounce or the check dishonor, which is going to happen. So from that stage also the advocates are there who are going to give the false promises and they are going to misguide the people because of their greediness for the short term or the money which they are asking. For example, if there is a check of 1 lakh rupees, so they will tell you can just stop this check. I'm going to help you. No need to pay 1 lakh. You just pay me 10,000, 30,000. So I'm going to settle the matter in the court. We won't be uh, paying anything to the complainant. So these kind of cases are going to arise from the initial stage itself. So as a person whom you have already been given the check, so you need to understand what is right and wrong, and this video is going to explain all the steps what the accused need to take care before it is too late. So friends, now let us understand the most important aspect under the check bounce, that is the advocate's false promise, which is going to begin. So many accused persons are misguided by their own lawyers. So whenever they go to their offices, they will try to, the advocates tend to smile them, they will make them comfortable, nothing has happened. It is just a piece of paper. So no need to worry about anything. In so the advocates what they do is instead guiding them in the right direction for the resolution, they are going to like feed them with the false confidence and delay tactics. They keep on talking with them just whenever they will go to the advocate office, the accused people. So they will try to misguide them by whispering and by making them feeling comfortable. Nothing is going to happen. I am here. So no need to worry. He is not going to do anything to you. So these kind of false confidence and delay tactics. Don't worry. We will delay it. No need to pay, so you should not able to pay at least a single rupee. So like these kind of statements which is going to misguide the accused person, and the accused is going to see the case only through the his advocate, the accused advocate, the false promises, so those only he is going to rely upon, and he's not going to see the reality. What is the legal reality is there, so that is a different aspect which advocate is not going to make you aware. So basically, you need to make sure that what is the reality. You need to consult a few more people. You need to go for other options. We need to ask for the learned advocates, the different advocates. Even though if you are not giving the case to them, you can just go and ask them. So this is my case. So is my advocate is telling me the truth? Am I going to save myself in the court? So what is the law? Because the accused people are going to be the normal people who are very very far away from the legal scenario, so they won't be knowing what is the reality. So everything what they are seeing is from their advocate eyes, which is always false. So the intention of this video is to make you aware, not to lose hope or the trust in your advocate. So, being accused or the person who is legally bound to pay to someone, what are the things you need to make sure and how you need to escape from your, that is the legal liability, either by paying it or by settling it. So, we will be seeing in this video. So, this video is not against any of the advocate because I am also advocate. So, keeping in that mind, so I'm just making this video in the wellness of the accused persons whom I have seen. They are roaming in the court, sitting from morning till evening, and they are giving fake promises from their advocate, and at the end, nothing is there. They are going to lose most of the uh, because the principal amount plus interest. Along with that, there is also going to be the you need to be there is a the accused person need to stay, that is there is imprisonment for the check bounce case. So all these things are there, so the accused are not aware of these things. So friends, the next aspect in this video we are going to see is the ignoring the legal notice. So when the legal notice is going to arrive, it is going to clearly state that you need to pay within 15 days of the, that is the payment time, or you are going to face the prosecution. But the accused, still under poor advice from his advocate, is going to ignore it, and no payment, no repay, no settlement. So his intention is to not to resolve the dispute rather than to escape it. So basically the accused are going to act on behalf of their advocate guidance. So here most of the accused are going to misguide from the first stage, that is when they receive the legal notice for the repayment of the check amount. So friends, now we will be looking into the very important aspect here, how to differentiate the legal liability. So now, if you understand this clearly, then you will be coming to know whether the case is going to stand in the court or not. So first of all, the legal liability is not about what you feel. So you may say that I'm not going to pay, I there is nothing from my end to pay or something like that. So it is not what actually what you feel, it's about what you have signed. So first of all, you need to make sure that whether you have issued the check to the payee, and if you have given the check for a debt and it is going to bounce, definitely this is going to cover under section 138 of the NI Act. So the law is going to presume the liability. That means you have given the check for the the legal enforceable debt. So for that reason only you have given the check. So the thing is that you need to also make sure whether you have uh, rebut with the solid evidence. That is no excuses. You need to make sure that if these things are there, then definitely you need to answer them in the court. So the next point is whether you have replied to the notice, that asking some time or mentioning that you have already paid or something like that. But the time frame is 15 days from the date from when you have received the legal notice. You need to repay to the complainant, and you need to also make sure, are you going to prove in the court that the check was misused and it is not meant for any kind of legally enforceable debt which you are supposed to pay to the complainant. So this is the very clear understanding of the legal liability. So again, I'm going to repeat it here. So the legal liability is not what you are going to feel, it's about what you have signed and you have admitted it and you have issued the check to the complainant. So this is the reality, and the reality is not something the accused is going to feel. So friends, now let's understand one more important aspect here. The law presumes guilt. So in almost all the check bounce cases, the law is going to presume the check was issued for a valid debt. So that means the law is itself towards the complainant. He has produced the check in the court along with the return memo what he has received, and then the burden is going to shift on the accused that he need to prove otherwise that this was a false thing. So without any strong evidence in the court, the accused is going to produce, the court is always towards the complainant. They presume that the complainant has a right to receive this amount, and the uh, the law also mentions that the check was issued for a legally enforceable debt. So this need to be proved by the accused otherwise that it was not paid for the any legally enforceable debt, and he need to bring a strong evidence for this in the court, otherwise the court is going with the complainant. So friends, now we'll be looking into another aspect, that is the missed opportunity to settle. So had the accused paid the amount or entered into a genuine settlement? So this is very important during the early stages in the court. So they need to either repay the whole amount in the check rather than arguing in the court and settle the matter. And the case never have reached trial. So basically these are the things where the accused is going to have two paths in front of him, where either he is going to settle it early or he is going to fight it blindly, sorry. So he is going to fight blindly without having any justification, any evidence, for which definitely he is going wrong and the judgment is coming against him. And the misguided advice from his advocate is going to lead him down the wrong path, and definitely for each and every the date for which the court is giving, so the case is moving towards judgment. So either they need to settle it early and they need to fight blindly with the advice what they have taken from their advocate. So most of the times the accused advocates, they never go for the settlement or the less amount what they have already given in the check amount. So likewise, and there is a delay in the time, so the complainant is not going to accept that one because he has there is a check what he has received, and there is also a lot of time for which the trial, sending the summons, and once the summons is going to serve, so after the arrest warrant, so after that the accused is going to come to the court, and after that as well we have seen the accused advocate, they do not give a fair amount in the settlement to the complainant lawyer. For example, if there is a check of 1 lakh rupees, the accused lawyer is going to tell 70,000 or 80,000 like that. So for this, the complainant will not be going to agree because he has spent a lot of time bringing the accused to the court, and he won't be settling the matter in the for the less amount, because in the check itself it has been mentioned definitely he is going to go for the compensation or for the judgment. So this is the missed opportunity for which the accused is having. So he can settle it in the court. So in the first or second trial, if he is going to bring the whole amount, filling towards the complainant's name in a DD, that is demand draft, and giving it the judge's hand. So the judge is also going to allow some reasonable compensation along with the check amount, and then they are going to close the case. So this is the opportunity which most of the accused are going to miss in the court, and it will tend to a very bad situation further. So friends, now we'll be looking into the final outcome after the misguide from the accused advocate. So what is going to happen is the conviction and there is going to be a regret. So the end result of fighting blindly, seeking advice of the wrong and the false misguide. So it is going to convict under section 138, that is the jail time, and then also there is going to be a fine to repay the full amount of the check along with the interest. All of this could have been avoided if the accused has acted responsibly at the notice stage itself. So they have missed everything, and now they will regret that what has where the situation has came with the wrong advice given by their advocate. So likewise, at this moment, if they have just repaid it during the notice stage itself, so there would have not be any kind of punishment to them. There is no interest to that. Only the check amount they could have given if it is a legally they would have uh, like legally they were supposed to pay to the complainant, so that they have just ignored and the situation has come to this stage. So friends, now we will see what accused need to do instead blindly fighting or taking the wrong advice. So first of all, they need to act wisely because they have something that is the legally enforceable debt. In those scenarios, they need to act wisely and they need to respond to the notice and they need to appear the hearings in court. And if in case there is any solid evidence against the complainant, what he has given, then that they need to produce in the court. And if there is a that is the legally enforceable debt, if the debt is genuine, then they need to consider the early settlement rather dragging the case to years, and they need to avoid the delay tactics because this is again coming back in a very wrong situation where they will be put behind the bars. So if in case there is anything which is legally you were supposed to repay to the complainant, you need to act smartly, not fighting blindly. So friends, now we have came to the end of the video. I hope you are now in a clear understanding of what you need to do if in case there is a genuine case and how you should not get misguided from any of the advocate, and you need to follow the correct legal approach so as to you will be either getting the settlement with the complainant or you will be uh, giving some solid evidence in front of the court against the complainant, so that your case is going to be strong, and that need to be a documentary evidence. Oral evidence are not going to be admissible in the check bounce related cases. So make sure that whenever you are defending, make sure to have an experienced lawyer who guides you accurately. So the lawyer, if he is like very experienced, he will close or settle the case in the notice stage itself. He won't giving the further stages to get arise. So in those scenarios, make sure to consult with other lawyers, experienced lawyers, and take a second advice. So this is the pen and paper YouTube channel. So if you found this video helpful, please like, share, and subscribe our channel. So we will see in our other topic. Thank you.